My lord, in item number 18, I am filing one additional affidavit already given. This may be called for. My lord. 18.
You are filing today?
Yes.
Okay.
Because in pursuant to this Lordship's interim protection, I have appeared in the exam, and
Okay.
my lord, actually it was supposed to be kept in the seal cover, but then Public Service Commission has declared mine. I am in the select list also.
Select list also.
Yes. And only
That is good for you.
good for me.
Ah,
So the appointment order has to be also issued now. So just we'll just close it today
okay.
Okay,
No.
by bringing on record.
by bringing on the records. The result.
My lordship, I beg to mention item number 15. The conducting council also now is out of station. I have taken the consent from the opposite.
Item
15.
15, hearing or out of session.
Yeah.
Adjournment. Huh? Okay. This is the one which we have. You are for the
Respondent
respondent.
on behalf of N. Dangan.
Okay. He's also not there.
Yeah.
Okay. Miss
M. Jarang.
Planning Council submits that the conducting council, Mr. Rajesh Sonar. The conducting council, Mr. Rajesh Sonar is out of station, therefore pray for adjournment of the matter. Mr.
J. Nino.
Planning Council also submits that, Nikita is also out of station,
Yes.
or made a similar submission that the Lanet is a legal aid council.
Yes.
No, Nikita is not a legal aid council.
No, legal
She
aid
is
council.
legal.
Yes.
Okay. And Gek Genie is legal aid council.
Before it was Gekken Jenny, sir, and after that,
Okay, okay.
now it is Nikita, ma'am.
Okay, he's also out of station. Is prayed for by both the Land Council appearing on behalf of the parties. The matter stand adjourned. List this matter after
2 weeks.
2 weeks. Mr. Jitado, Land PP is present. Then, further, just a minute. Kekenjini is no longer legal aid council here.
Yes.
Okay. The registry shall struck off the name of Sri Gekken Jini, Land Legal Aid Council, who earlier appeared as a legal aid council from the cause list. Okay.
Much obliged.
Lordship, I'd like to mention item number 4. On behalf of leading Constable Koyang, sir. He's out of station for his personal works.
Okay. Okay, Mr.
B. Masom.
Land Council, submitted. The conducting council, Mr. S. Koyang,
Lordship,
is out of
2 weeks may be given. 2 week
therefore
time may be
pray for
given.
adjournment of the matter for 2 weeks.
Yes.
Okay, the prayer is allowed. List this matter after 2 weeks.
May I please, Lords. Lordship, I beg to mention item number 11, my lord.
Item
11, my lord.
11.
Yes, my lord. In this matter, my lord, the respondent had filed their affidavit in opposition, my lord. I need further 2 weeks' time to file affidavit.
reply
in
not yet filed.
Not yet filed, my lord.
Okay. Sir,
Lordship, I'm appearing for respondent number APPAC, Your Lordship.
okay. Mr. H. Lampu. Prays for further 2 weeks' time to file affidavit in reply, to which Ms. Ananjo, Land Standing Council for APPSC, has no objection. Prayer allowed. List this matter after 2 weeks.
Lordship,
But
Yes.
can it be a fixed date?
When?
18th.
18th.
Should be
18th May?
should be on Tuesday and Thursday. Okay.
Yes, 19 is Tuesday, 18 is Monday.
Okay.
The Lordship on 19th.
19. Okay.
Obliged.
As prayed, as requested. List this matter on 19.
Obliged.
May it please, Lordship.
Yes.
I would like to mention item number 16 for the petitioner.
16.
Yes, Lordship. The land leading council for the petitioner is out of station due to family exigency.
Okay.
They kindly adjourn the matter for 2 weeks.
You are Mr.
LAC Deni Dignium,
mentioning on behalf of,
Morik
The-
Bagra, LAC.
okay, Morik Bagra, similar order, huh? Out of the station, okay. So Mr. The Lanet conducting council, Mr. Morik Bagra is Lanet legal aid council, huh? Morik Bagra is out of station, therefore pray for adjournment of the matter for 2 weeks. This test matter after 2 weeks, okay. So
Item number 1 and 2.
May I please, my lord?
Yeah.
My lord, in item number 1, on 9/2/2026, I have submitted that the petitioner want to engage some another counsel in this case.
okay,
So this item number 2 is a similar matter, my lord.
in
I'm not in the-
in item number 1,
Yes.
they have engaged another council.
Uh,
They say that they will
Yes.
engage.
Yes.
So, not yet engaged.
Not yet engaged on 10/2/2026 on El Tatam, who is also my associate member. He was entered appearance, but he will not continue in this case. So petitioner want to engage some another advocate instead of us.
Okay. Mr. N. Taji, land counsel for the petitioner. When first it was informed?
My lord, on 9/2/2026.
9/2.
Yes.
Mm. Service said the petitioner wanted to engage another advocate, another set of advocate. It was informed way back in February. Okay. However, no one appears on behalf of the. So now you are no longer appearing. No, you will not be appearing any.
Yes, my lord.
Okay, and as such, he will no longer be appearing. So you want that your name be removed?
My lord,
You want that your name be removed?
my name may be struck out, my lord.
Okay.
And all associate Tatam and Takam.
Licha Tatam also?
Yes, and Likha Takam also.
Okay. Another set of advocates, and therefore their name may be struck off from the cause title and a cause list as a counsel for the petitioner. However, no one appears on behalf of the. No one appears. Huh? No new advocate appears for the petitioner. Staff. Huh? The prayer is allowed. Let the name of Sri
My lordship.
Nilam Taje, Licha Tatam, Likha Takam, and Likha Takam be struck off from the cause title, the cause list. Staff. Huh? The registry shall re-notify the petitioner regarding the withdrawal of the counsel appearing on his behalf. Staff. Huh? Mr.
My lordship, I'm for the item number 2,
Okay.
which is connected matter.
Mr. Tapin Lanet, senior government advocate, is present on behalf of the respondent. Staff. Huh? And Ms.
M. Jarang,
is also present
petitioner
in item for the petitioner in item
number 2.
2. Okay, staff. In view of the above, list this matter after 3 weeks.
The
You also inform? Yes,
matter may fix on 28th of May.
28 May.
May.
28th May.
Okay, as requested, list is matter.
No.
28 May is Tuesday, Thursday.
Thursday.
My
Okay,
lord,
28
my lordship,
May.
it is not possible
Hmm?
because the conduct, if it is possible on 1st June.
First June.
First June.
First June,
2nd June.
Second June.
2nd June, okay.
All right.
Item number 3.
May it please, my lord. I seek your lordship's permission to address through VC.
Okay,
My lord, this matter
Yes.
comes up pursuant to the single judge's order of 20th April 2026, my lords, when the matter is placed before the division bench. As, my lord, there is a challenge to the recruitment rules, my lords, of 2025. Now, lords, I appear, my lords, for the petitioner, Mr. Himarete, and, my lords, the challenge in this writ petition, my lords, is to the seniority list of 18 February 2026, which is Annexure 18, my lords. I will take your lordships to the document, my lords, just before that, giving a flavor of the case, my lords. Fixing inter se seniorities, my lords, of urban program officers, my lords. This your lordships knows, my lords. In the Department of Urban Development and Housing, my lords, there are, my lords, Assistant Urban Program Officers, AUPO, which are equivalent, my lords, to Assistant Engineers.
No, AUPO-G.
So, AUPO is equivalent to Junior Engineers.
AUPO is E.
The next grade post, my lords, is Urban Program Officers, UPO, which is equivalent to an Assistant Engineer. And then, my lords, Executive Engineer, followed by Superintending Engineer. Now, my lords, as I said, my lords, this matter has a checkered history. My lords, in 2008, my lords, 16th July 2008, the DPC, my lords, was held for inter se seniorities of urban program officers. And in that DPC, my lords, the petitioner was at serial number 6. Over, my lords, the respondent number 4, my lords, who was at serial number 7. Now, my lords, the dispute today is inter se seniority between the petitioner and the respondent number 4. Now, my lords, that DPC decision of 16708, my lords, I will take your lordships to the document before just giving a flavor, was challenged, my lords, in a writ petition before the court, High Court. In that writ petition, my lords, the state government defended the decision of DPC in their counter affidavit.
It should be from the date of absorption.
And the stand of the state, my lords, was that the seniority will have to be counted from the date of absorption in the cadre. That is the stand, my lords. I will place it, my lords.
Where is
Sing-
that?
My lord, that your lordships will find straight away at page 297, my lords, of the additional documents. My lord, my friend has filed an additional document.
Starts at 295 at 297.
Starts at 295 at
Annexure
290 at
Annexure
297.
12 of additional affidavit.
I'm grateful. Let's show.
297.
Yes, my lords. Paragraph 6, if your lordships have, my lords.
Yes.
That with regard to the statement made in para 9 of the writ petition are denied, the respondent number 3 was appointed. The writ petition was, my lords, by the respondent number 4 here. Well, the respondent number 3 was appointed as JE in his parent department in the year 1994. Thereafter, he was appointed as Assistant Urban Program Officer in the year 1997 under the Urban Development and Housing Department. Subsequently, was absorbed permanently in the year 2001, and as per the provisions laid down in the book Establishment and Administration with heading recruitment by absorption deputation, clause 11. Seniority of persons absorbed after being on deputation, subclause states that, I'll read that, my lords. In the case of a person who is initially taken on deputation and absorbed later, that is where the relevant recruitment rules provide for deputation/transfer, his seniority in the grade is which he is absorbed, which will normally be counted from the date of absorption. Please mark that, my lords. If he has, however, been holding already on the date of absorption the same or equivalent grade or regular basis in his parent departments, such regular service in the grade shall be taken into account in fixation of his seniority, subject to the condition that he will be given seniority from the date he has been holding the post of deputation. If your lordships come down, or the date from which he has been appointed on a regular basis to some or equivalent grade in the cadre department, parent department, whichever is earlier. Thus, as per the recruitment rules, the respondent number 3 ought to be promoted in the year 99 as per his qualification and service tenure, whereas he was time deprived of his promotion quota by appointing person from other works department on deputation by depriving the promotional quota of the respondent number 3. That's the petitioner. Therefore, claim of the petitioner who was appointed on deputation against promotional quota do not bear any reality. Rather, the petitioner should be grateful to the department for considering him for appointment of deputation and absorb letter. This is a clear-cut example of accusation of an accused. But this is the stand, my lords, of the State Department, my lords, before your lordship's court in the first round when the single judge, my lords, writ petition was filed. Now, my lords, single judge dismissed the writ petition on 4th November 2013. That order your lordships will find, my lords, 46. At page 46, my lords, of the paper book of the writ petition. The single judge held, my lord, there is no merit. And if your lordships come straight away.
Annexure 6.
Yes, my lords. Annexure 6.
Page 46.
And if your lordship, if I take your lordship straight, my lords, to the paragraph 36, my lords, the last page of this order. In view of our foregoing discussions, my lord has it.
Yes.
In view of our foregoing discussions, I have found that the petitioners were absorbed as UPO in Housing Department with effect from 20th August 2004, whereas the respondent number 3, which is the petitioner I am representing, was promoted to such post with effect from 22/10/2001. That being so, in the grade of UPO in the Housing Department, the respondent number 3 is pretty senior to the petitioners herein. Thus, one cannot find fault with the state respondent in placing the respondent number 3 above the petitioners in the seniority list dated 16 July 2008. Now, this order was carried up in appeal before the division bench. And the division bench judgment, lordships will find, my lords, Annexure 7 at page 58. Division bench, my lords, set aside the single judge judgment. This is dated 28th January 2016. And I'll take your lordships, my lord, straight to the operative part of this order. The division bench, my lords. Paragraph 21, if your lordships take, my lords, running page 67 of the writ petition, holds para 21, my lords.
Yes.
The committee which finalized the criteria to be followed in fixing inter se list of UPOs in its meeting held on 11/7/08 had held that the guiding principle is that the absorbed person is treated on par with direct recruitment, and his seniority is always counted from the date of absorption. And in case of persons who were absorbed on same date, the determining factor for counting seniority shall be the date of joining to the new post. Accordingly, the committee had decided to reckon the date of joining as determining factor for the officers who were absorbed in the department on the same date for fixing seniority. In case of promotion, the general principle is that the promotee shall always come first over the absorbee in a recruitment year like so-and-so. Thus, the decision of the committee in its meeting of 11/7/08 was to the effect that the promotee should come first over and absorb in a recruitment year. Thus, the respondent number 3, who was promoted as UPO with effect from 22/10/2011, should be made senior to the applicant who was absorbed with effect from UPO with effect from 12/4/2001. This principle enunciated by the committee in its meeting dated 11/7/08 could not, in our view, be made applicable to the present case due to the reason that the order of 23/8/2004 absorbing the appellant as UPO with effect from 12/4/2001 had given certain rights to the appellant. The right of seniority had accrued to the appellant by order dated 23/8/2004. Your lordships will mark this, my lord. This order is at page 43, my lord. I'll take your lordships to this order later on. Could not have the right of seniority that had accrued to the appellant by order dated 23rd August 2004 could not have taken away by the committee meeting minutes dated 11/7/08. In the present case, please mark this, my lords, no recruitment rules were shown to us which should govern seniority of the employees of the concerned department. I pause here for a moment, my lords. The recruitment rules of 1998 was in force. That was missed out by the division bench, my lords. And then it is said, it is settled law that in the absence of rules governing seniority, length of service is to be counted for the purpose of seniority. In the present case, not only has the appellant been in service for a longer period as UPO than the respondent number 3, but also the appellant's absorption as UPO has been made prior in time to the promotion of the respondent number 3 as UPO in the said department. Then, my lord, 22. Another aspect of the matter which has to be considered is with respect to term number 1 of the order of 23rd August 2004. Term number 1 is as follows. The inter se seniority of the officers shall be decided after conducting DPC by a board based on performance cum merit of the above officers. The insertion of this term number 1 in the order dated 23/8/2004 creates an impression that the order dated 23/8/2004 has not fixed the seniority of the appellant as UPO with effect from the date of joining the department, that is 12/4/01, but counts the seniority of the appellant as UPO from the date of absorption, that is 28 August 2004. This term number 1, in our view, cannot be read into the order dated 23/8/04, and the same is inapplicable to the facts of the case. Firstly, as held in the earlier paragraphs, the appellant date of absorption having been retrospective effect from the date of joining, that is 12/4/01, the appellant date of absorption as UPO on permanent basis has to be taken from 12/4/01. Secondly, the criteria for counting seniority of officers has to be from the date of joining or date of promotion and dates of appointment or length of service. The term number 1, whereby the seniority of the officers was to be decided based on the performance cum merit after date of joining, etc., is alien to service jurisprudence. There can be no nexus for determining seniority based on the performance cum merit unless a new appointment or promotion is to take place. In the present case, the appellant has already been absorbed as EPO permanently with effect from the date of joining in the department. The insertion of term number 1 is an exercise in futility and cannot be contemplated under service jurisprudence. Last but not the least, the committee which decided the criteria to be followed in determining seniority of its meeting dated so-and-so has not followed term number 1 of the order of 23/8. In view of the fact that the right has accrued to the appellant to count his service in the grade of UPO with effect from 12/4/01 has not been taken away, the appellant's seniority in the grade of UPO has to be counted with effect from 12/4/01. Seniority of the respondent as per order is so it's. I pause here. Your lordships will just come to page 43, my lord. That's that order, my lord, which the single judge division bench holds. My lords, the term number 1, just have page 43, my lord. And this is the order, my lord, Annex 4. Which has created the ambiguity. My lords, has page 43?
Yes.
Yeah, this is the order of 23rd August 2004, my lords. And please see, my lords, order. Consequent upon acceptance of option exercised by the owing JEs for absorption in the Department of Urban Development on the basis of NOC gained from SC additional CE coordination APPWD Itanagar, the governor of Arunachal Pradesh is pleased to absorb permanently the following JEs civils of PWD in the Department of Urban Development as urban program officer in the interest of public service at the existing scale pay of so-and-so. Please mark, my lords, with effect from the date of joining in the department as per details given below. So it says with effect from the date of joining of the department. Now please have the order. Name of officers, R.D. levied. He is respondent number 4, my lords. and date of joining is 12/4/2001. 1, 2, 3, the fourth column. And the fifth column, your lordships will see date of absorption is 20th August 2004. Right, my lords?
Yes, yes.
If we go by the date of joining, your lordships will see the last one, Engineer K. Indu Singh. Your lordships have that, my lords?
Yes.
His date of joining is 29 March 2001. He is even prior to R4, but he is not given that seniority. If date of joining is the criteria, my lords, then K. Indu Singh will come above R.D. Louis. Now, my lords, please see condition number 1, which the division bench, my lord, which respect held that this condition was unnecessary. The inter se seniority of the officers shall be decided after conducting. Your lordships have condition number 1.
Yes.
The inter se seniority of the officers shall be decided after conducting DPC by a board based on performance cum merit of the above officers. So, my lords, if condition number 1 is there, my lords, it has to be, my lords, seniority will be decided by the DPC. If date of joining is the date, my lords, which has to take trigger, then DPC is unnecessary, my lords. It is on basis of seniority, you will get that promotion, seniority. Now, my lords, the division bench order was challenged before the Honorable Supreme Court of India in a special leave petition. And the Supreme Court, my lords, by an order of 8 April 2016, that's at page 70 if your lordship goes, my lords, granted leave and ordered status quo. Page 70.
That is when on
76.
842016.
Yes, my lord, I'm grateful, my lord. That's Annexure 8.
Page 70.
Page 76. Your lordship has that, my lord?
Yes.
Justice Chalameswar and Justice Sapre, leave granted. Status quo obtaining as on today shall be maintained until further orders. So, my lords, the special leave petition was pending before the Supreme Court. There was a status quo order granted in 2016. And now, my lords, see what the state does. Now, state, my lords, please note the date, my lords, on 7 February 2025, files an application before the Supreme Court stating that under the rules that are applicable, namely, my lords, the recruitment rules of 2014, my lords, the promotion will be only on merit. They say seniority is immaterial now. Once you are in the cadre of junior engineers, your promotion to superintending engineer will be on merit. So the impression which the state gives to the Supreme Court is that this list has become unnecessary now because seniority is not the criteria. We will go only on merits. Now, please see, my lords, this application. I want to place this application of the state, my lords.
71.
Page 71, Annexure 9. Because something to say about the state, my lords. Matter was pending in the Supreme Court, my lords. Seniority was to be decided by the Supreme Court. Court granted status quo in 2016. In 2025, my lords, the state filed an application on 7 February 2025 seeking permission to conduct DPC for superintending engineer civil, stating, my lords, that there are 4 vacant posts. Now, please have that application, my lords. I've said, my lords, this starts at page 71. Please come to page 75, my lords, paragraph 3. What the state represents to the Supreme Court. My lords has paragraph 3.
Yes.
Yes.
My lord Justice Kalita.
Yes, yes.
Yes. The applicant further submits that the controversy before this honorable court in the present civil appeal is regarding the seniority of the appellant, which is the petitioner here, and the respondent number 1, who is respondent number 4 here, in the cadre of executive engineer. Since promotion to the post of superintending engineer is purely on merit, please mark, my lords, irrespective of seniority, no prejudice will be caused to either the appellant or the respondent number 1 if the applicant is granted permission by this honorable court to conduct the DPC. The applicant further submits that since, please mark this, my lord, promotion shall be purely on merit, the controversy before this honorable court regarding inter se seniority of the appellant and the respondent number 1 does not survive any longer. And then, my lords, please come, my lords, to paragraph 11 at page 78. The state, my lords, informs the Supreme Court, seniority is immaterial now, we will go only on merit.
Based on the 2014 rules.
Under the 2014 rules, your lordships will just mark, under the 2014 recruitment rules. Now, para 11, the applicant submits that the Department of Urban Development, Government of Arunachal Pradesh is functioning without a superintending engineer civil for the last many years. Presently, there are 4 clear vacancies to the post of superintending engineers, and given the vastness of the state with 28 districts, the chief engineer alone cannot effectively oversee and supervise developmental activities across the states. Numerous time-bound projects and schemes required continuous and regular supervision by senior officers. It is submitted that the department is in, please mark, acute need of filling up the vacant post of superintending engineers. And in terms of this Honorable Court's order of 55/11/2020, the present application has been filed seeking permission of this Honorable Court to make appointment to the vacant post of superintending engineers by convening the DPC. Please mark the next line. The promotion shall be made in terms of the recruitment rules of 2014, which provide that irrespective of seniority in the cadre of executive engineers, the promotion shall be made only on merit. And please see the prayer, my lords. Grant permission to the respondent number 2 to conduct the DPC meeting for promotion to the post of superintending engineers of Urban Development Government of Arunachal Pradesh in terms of the recruitment rules of 2014. Now, my lords, the Supreme Court on 18th March 2025, your lordships will find that order, my lords, at page 89. No, first page 89, my lords. Annexure.
So this is incomplete.
Annexure 10. The lordships have that, my lords?
Yes.
Justice. The civil
Yes.
appeal is disposed of in terms of the signed order. The signed order, your lordships will find, my lords. I'm sorry, it was not filed with the writ. Is at page 435.
435 in additional
435.
affidavits.
435, my lords.
Page the documents.
Annexure 24, my lords, has that?
Yes.
This civil appeal, then it paragraph 2 quotes the prayer. My lords, Justice Habum.
One second. One second.
Just. Yes, para.
No, the first para 1 and 2, your lordships will come to paragraph 3. In view of the interlocutory application, the contesting parties, please mark, will now be entitled to be considered for the next promotional post of superintending engineer civil. This application becomes necessary because of the interim order passed by this court on 8/4/16 directing maintenance of status quo pending disposal of the civil appeal. Please mark, my lord. In view of the fact that the parties have now become entitled to be considered for the next promotional post, the existing list becomes unnecessary to be adjudicated upon. Because the state represented, my lord, seniority is no longer an issue. We will go purely by merit. And the appointment, my lords, as superintending engineer will be on merit.
430.
Yes. Now, my lords,
4th of July 2025.
after this, my lords, now see what the state does, my lords. The state government, my lords, on 4th July 2025, amends the rule. And this is, my lords, superintending engineer commencement common recruitment amendment rules 2025, which I have challenged, my lords, the validity of these rules. Your lordships will come straight to page 220 of the writ. The impugned rule, my lords.
We compare with page 91.
220, your lordships have, my lords.
Yes.
Before that, my lords, may I take your lordships to page 91, the 2014 rules, which the state says we will go only by the 2014 rules. That rule, my lords, your lordships will find
90 and 90.
At page 90,
Annexure P11.
annexure
P11.
P11, annexure 11. My lords, have page 90.
Yes.
At 91.
At 91, if your lordships come, my lords, serial number 11. So this is what the state represented, that this is the rule. We will go purely on merit. Seniority has become immaterial, so the list has become dysfunctional. My lord, the list can be disposed of. Supreme Court, based on the representation of the state, disposes of the civil appeal. And please have that rule, my lords. Serial number 11 in the table at page 91 schedule. In case of recruitment by promotion, deputation, transfer, grades from which promotion, deputation, transfer is to be made. Please see the right-hand column. By promotion from amongst the executive engineers of the department who have completed 10 years of regular service in the grade, provided that irrespective of seniority, please mark this part now. This is what the state represented to the Supreme Court. Irrespective of seniority in the grade of executive engineer, the promotion to the post of SE shall be considered in order of merit from eligible candidates. Now, this proviso, my lords, has been deleted by the impugned.
Mr. Chaudhary, I mean, what happened in 2016? This rule was in existence at that point of time.
Yes,
When the Honorable Supreme Court passed the status quo order.
yes.
This rule was in existence.
Yes, this rule was in existence. This rule was in existence on the day when the Supreme Court disposed of the civil appeal, based on the representation made by the state, that merit is immaterial, that seniority is immaterial for the cadre of superintending engineer. It is only merit.
Correct, correct. Now, what is the amendment they have
Now,
done?
my lords, please see the amendment
At page 220.
at page 220,
Annexure 14.
annexure 14, my lords. And this, my lords, in my respectful submission, my lords, state cannot do this. They are stopped by the pleadings made before the Supreme Court. And this rule, my lords, has been brought in to my detriment. After having solemnly represented before the Supreme Court that we are going only on merit, seniority has no basis. Now, please see these rules, my lords. At page 220. My Lord Justice Abong?
Yes.
Yes. Short title, these rules may be called. This is, my lords, notified on 4th July 2025 at the top right-hand side, your lordships will see, my lords. In exercise of powers under Article 309. And that's why, my lords, that the writ petition is placed before the division bench. These rules may be called the Superintending Engineer Common Recruitment Amendment Rules of 2025. Now, please see, in the principal rules in the schedule in column number 11, that is page 91, your lordship saw, for the existing entries, the following entries shall be substituted, namely, by promotion from amongst the executive engineers of the concerned departments with 10 years of regular service in the grade level so-and-so. So, my lords, that proviso has been done away with, which only confined it to merits. Right, my lords? So my challenge, my lords, to this rule is that state, my lords, is stopped by pleadings, having pleaded before the Supreme Court that we are going by the 2014 recruitment rules, that we will consider this petitioner, the appellant therein, and the respondent number 1, who is the respondent number 4 herein, only on the basis of merit. So the issue of seniority has become immaterial, and the court, relying on that representation, says that the lease has become unnecessary because it is only now on merits. Right, my lords?
Yes.
Now, when this happened, my lords, we went back to the Supreme Court. We filed, my lords, an application seeking recall of that order, saying that this is what the state has done. State has tried, my lords, to my detriment, brought in a rule amendment after the order was passed, to my detriment. So my seniority will have to be decided by the court. That application, your lordships will find, my lords,
At 381.
at page 381.
Annexure 23.
It starts, my lords, at 387.
381.
381. Right.
The prayer is 405.
The prayer is that, my lords,
405.
page 405.
No, 396. Sorry. 396.
Oh, sorry, my lords, page 396. Come on, yeah, Karma, you also. Page 396, my lord, we are saying, recall the order of 18th March 2025. And before that, my lords, please allow me to read, my lords, paragraph 16 at page 395. I will read from paragraph 14, my lords, 392. My lords, has paragraph 14?
Yes.
That in complete volte-face to the stand taken by the respondent number 2 before this honorable court in IA number 37708 of 2025 and the provisions of the Superintending Engineer Common Recruitment Rules 2014, the state respondent has issued a notification dated 4/7/25 published in the Arunachal Gazette and has amended the Superintending Engineer Common Recruitment Rules 2014 by notifying the Superintending Engineer Commencement Recruitment Rules 2025, whereunder the words appearing in column number 7, which read as under. I've extracted it, the earlier rule and the amendment. Then please read that sub-paragraph. The deletion of the proviso which prescribed, my lords, has that sub-paragraph. The deletion of the proviso.
Where?
Just below 393, just below the extracted.
Okay.
The deletion of the proviso which provided that the promotion to the post of superintending engineer shall be considered in order of merit, irrespective of seniority in the grade of executive engineer, is a conscious and deliberate attempt on the part of the state respondent to pass a consequent order in favor of the respondent number 1, which is in complete violation and infraction of the submission undertaking of the state respondent before this honorable court, and tantamount to misleading this honorable court and undermining the majesty of this court, which action ought not to be countenanced and condoned by this court. Then the para 15. Then in pursuance of such a deprecating act on the part of the state respondent, and contrary to the statement made before this honorable court, the applicant has every reasonable apprehension that the state respondent will now publish an interstate seniority list of urban program officers by placing the name of the respondent number 1 above the name of the present applicant. The state respondent, the duty bound, and this has happened, my lord. This is, my lords, the impugned seniority list of 18 February 2026. They have now, my lords, published the seniority list. And, my lords, then come to my prayer, my lords. Prayer is at page 396. And please see the order of the Supreme Court on this, my lords. 28 November 2025. That's at page 222, my lords.
Annexure 15.
Annexure 15. The state can't do this, my lords. They tell the court we are going ahead only on merits, and then they, my lords, change the rule itself. Now, please have 222. So our application is taken up by the Honorable Supreme Court, my lords. This is Annexure 15. My lords have it?
Yes, yes.
The
Yes.
petitioner is concerned with the applicability of the amendment which came subsequent to our order of 18th March 2025. While we dismiss the miscellaneous application, which is totally misconceived, please mark, my lords, we are of the opinion that the amendment which came subsequent to the order passed by this court gives fresh cause of action to the petitioner. In this view of the matter, we allow the petitioner to avail such remedy as may be available to him against the amendment or other relief. If such remedy is invoked, please mark, all contentions are left open to the petitioner to agitate before the appropriate court set forum. So when the Supreme Court said, yes, you're aggrieved by the rule, the amending rule of 2025. This is a fresh cause of action. Go before the court. And if such a remedy is invoked, please mark this part, my lords. all contentions are left open to the petitioners to agitate before the appropriate court. So,
But
my
no
lord,
interim relief was given to you. No interim relief was given to you.
no, but Supreme Court can't give, my lord. Supreme Court has already disposed of. My interim relief was continuing from 2016, status quo. Now,
That
Supreme
has
Court,
already gone.
no, Supreme Court disposed of the SLP based on the state's application that we will go only on merit. Right, my lords?
Correct.
After
Correct.
that, I went up before the court saying that this is what the state has done. Court said, Supreme Court said, this gives rise to a fresh cause of action. You go and invoke that remedy before the court, appropriate court. And when you invoke that remedy, all rights and contentions are left open to be agitated before this court.
Now,
Right,
those
my
have
lords?
to be done afresh.
Yes.
Those have to be done afresh, right?
That's why, my lords, based on this Supreme Court liberty, I have come before your lordships in this writ petition. And I am challenging, my lords, apart from the rule of 2025, which I respectfully submit, my lords, it suffers from manifest arbitrariness. The state, having represented before the Supreme Court that we are going to consider the appointment, the promotion to the post of superintending engineer only on merit. That's why the list has become unnecessary. The inter se seniority between respondent number 1 therein and the appellant, who is the petitioner here, has become unnecessary because now their promotion to the post of superintending engineer has to be considered. After that, my lords, when the pleading is made, my lords, before the Supreme Court disposed of the civil appeal. State cannot, my lords, turn a volte-face and bring about an amendment to the rule to my detriment. My respectful submission is, my lords, state is stopped, my lords, from pleading to the contrary. A. B, my lords, my case is, otherwise, my lords, the inter se seniority issue was not decided by the Supreme Court. On the submission of the state that it is not necessary, don't decide. Because the list now has become unnecessary, we are only going on merits. Now, after the order of the Supreme Court, my lords, and the amended rules, please see, my lords, the final seniority list of UPO at page 232. Annexure 18. Annexure 18, my lords. This is the impugned. Page 232, my lords, has 18 February 2026. My lord, Justice Habum?
Yes.
It's running page 232, my lords. On recommendations of the board meeting held on 5/2/2026 at so-and-so in the office of so-and-so, in pursuance of so-and-so, convene the claims and objections submitted against the provisional inter se seniority list of urban program officers under the Urban Development Department. The final inter se seniority list of urban program officers is hereby notified for information of all concerned. And please see, my lord, 233. The respondent number 4 is placed in serial number 1. And
You are
I am,
number 2.
No, I'm in 2. Yes, I'm Hima Rete, my lords. I fall in number 2.
Yes.
So my respectful submission is, my lords, that this A
So now they have given on the basis of date of absorption or date of promotion.
now, my lords, according to this is the date of joining.
Correct. So date of promotion they have given. They have again
Yeah.
gone back to the earlier one.
Yes. No, state has not gone back to the earlier one. State's case was, my lords, that state's list, if your lordships recall, my lords, that list at page 40, that inter se seniority which was decided by the DPC of 2008, my lords.
Page 40.
Your lordship, no, my lords, that yes, 16708 DPC, page 44, my lords.
Page 44, yes.
That said, my lords, that the rule then existing was, my lords, first you will, my lords, take it from the cadre of AUPO. And if they are not available, then you will get deputationists. Please have the 1998 rules, my lords. I need to place that also. That is at page 269.
1998.
Page 269, my lords.
Starts at 266.
Starts at 266. Well, state can't play ducks and drakes here, my lords. Having taken a position, my lords, in the earlier round that it is the date of absorption from which, my lords, the seniority will have to be counted. States stand here, my lords, is my lords quite. I don't understand how the state has acted like this. Now, please have, my lords, the seniority rules, the recruitment rules of 1998 at page 266, my lords has.
Yes.
This lays down the method of recruitment. My lords, your lordships will say, my lords, these rules may be called the Urban Program Officers Recruitment Rules of 1998. And, my lords, please come to page 269. My lords, has 269. This is, my lords, for Urban Program Officers,
Equivalent to E.
equivalent to Assistant Engineer's post. And if your lordships come to page 269, and the seniority was fixed, my lords, on the basis of this rule. Just have the column number 3, my lords. Method of recruitment, whether by direct recruitment or by deputation/transfer, and percentage of vacancies to be filled up by the various methods. Please see, my lords. 50% by promotion from AUPOs who have completed 5 years of service for degree holders. So, my lords, 50% from Assistant Urban Program Officers
Feeder cadre.
who have completed 5 years. This is the feeder cadre, my lords. And number 2, my lords, 50% by direct recruitment to be conducted by the APPSC on the basis of written examination, followed by viva voice. 80% of the post meant for direct recruitment shall be reserved for APST.
At this point, I'm the only.
So, my lords, my submission is this, my lords. On 50% by promotion from AUPO, the petitioner was the sole AUPO who was eligible for promotion, my lords, on this 50% cadre quota. So first mode is 50% from promotion, 50% by direct recruit. Right, my lords? Now, please have the next column. In case, please mark, my lords, in case of non-eligible from amongst AUPOs, the post will be filled up by deputation from amongst the AEs, JEs who have completed 5 years or for degree holders in civil engineering. So, my lords, I came under the 50% quota on promotion. Since the other posts were vacant, deputationists were brought in.
R4 is a deputy.
R4 is a deputationist. So he cannot defeat my rights, my lords. I was available in the cadre.
That is the reasoning given by DPC.
And that is, my lords, the reasoning given by the DPC
On 11th of July 2008.
on 11th of July 2008
At 292.
at page 292. If your lordships come to 292, my lords. So state, my lords, has interpreted the rule in my favor, and rightly so. Now they cannot, my lords, turn a complete somersault and tell the court that no, now we have brought in the rule. Please have, my lords, page 291. There's a minutes of the meeting dated 11 July 2008. And straight away come to page 292, my lords. This explains it, my lords. Page 292, my lords, if your lordships read, my lords,
Yes,
the second paragraph, as per the general principles, my lords,
yes, yes.
this answers it. As per the general principles of seniority and other relevant guidelines issued by the Government of India, as well as the state government of Arunachal Pradesh, in case of the counting of service of deputation is absorbed later on the department, the guiding principle is that the absorbed person is treated on par with direct recruitment, and his seniority is always counted from the date of absorption. Please mark this, my lords. And in case of persons who were absorbed on the same date, the determining factor for counting seniority shall be the date of joining to the new post. So if they are on the same date, then the date of joining. Otherwise, my lords, the seniority is always counted from the date of absorption. So at page 43, my lords, where the date of absorption is given, my lords, that is the date from which the seniority will have to be counted.
From the date when
He came into the cadre as a deputationist, my lords, much later than me, my lords. I was already available to be promoted as UPO, AUPO.
But as per the list in page 233,
Yes, my lords. Yes.
233.
Yes. No, my lords. Before that, your lordships come to 292, my lords. That same list which I was pointing out. There,
Yes, same list, yes.
I am serial number 6.
You are serial number 6, yes.
And 7 is respondent number 4.
Hmm.
Serial number 7, my lords, is R.D. Lewis.
Yes.
So, my
But
lords,
in the list of 233,
yes, my lords.
the list given in 233,
Yes, the impugned one.
yes, the RD
Yeah.
leave is not there.
R.D. Lewis, he's the name, man. The Rocco Tumming, his name, I think, our name has changed. He's the same gentleman, R4. Rockpo.
Same gen.
Yes. Rockpo Tumming.
Okay. But as per this, his date of absorption
Yes.
is 12/4/2001, whereas
Yes.
yours is 22/10/2001.
No, man. That is the day when he came on deputation. But his absorption, page 43, if your lordships come back again, my lord, that's the order which has created this confusion. Otherwise, just have page 43. This gives the date, my lords.
Yes,
RD,
page RD Levy 28/2004.
yes. So seniority will have to be counted from 28 August 2004. That's the state stand. And that's the right stand, my lords.
No, but then why they are rewriting date of promotion stroke absorption as UPO?
Sorry, my
In
lords.
233, in page 233,
Yes, my lord.
then why they are writing it as
Yes.
date of promotion stroke absorption as UPO?
This is wrong.
This is wrong.
2001.
This is wrong, my lords. That's my challenge, my
That's
lords.
what that is why I'm asking.
I'm
How
grateful.
can they do it? I mean,
They cannot.
because that they are giving two dates.
Yes.
Yeah, at page 43, they are giving a different date of
Yes.
absorption.
Yes.
And page 233, they are giving a different date of absorption.
That's what, my lords. Then this is why has this happened? Because state, my lords, have not kept their stand. They are, my lords, going up, going down. Before the Supreme Court, they say we'll go only on merits. Is that fair, my lords, to a citizen? Is this the way you treat an officer, my lords? You represent to the Supreme Court that we will
No,
go
they
on
have to
merit.
answer this. They have to answer this because in page 43, they have given date of joining
Yes. And date of
on
absorption.
deputation, on the deputation and absorption.
Yes.
But whereas they have in the impugn thing, they have come up with different.
I'm grateful, my
different
lords.
dates.
I'm grateful. There's a
Different
lot of
dates.
ambiguity. So all I am saying is, my lords, your lordships will have to, my lords, what I'm saying today is, my lords, let them maintain status quo, my lords, because they are now going ahead. Because, my lords, your lordships will see, my lords, the impugned seniority list I have challenged is 18 February 2026 at 2:32, which your lordship just read. And on 12 March 2026 at page 234, my lords, Annexure 19.
They have come up with provisional.
They have now, my lords, published the provisional seniority list of executive engineers for considering to promotion to the post of superintending engineer
Following the
at 234 at 235. And 234, my lords, follows the 2025 impugned rules. Now, please see, my lords, this order itself. 234. They are referring to the Supreme Court order. Para 2, if you see, Lordship, see, after the board, after proper examination of the above mentioned fact, has advised the Urban Development Department to pursue the special leave petition pending in the apex court and request to vacate the judgment dated 3/4/2016. Accordingly, department pursued in the apex court, filed interlocutory application. The apex court in the judgment allowed interlocutory, disposed of the civil appeal. Nonetheless, after the disposal of the civil appeal of the Honorable Apex Court, a provisional interstate seniority list of urban was prepared in compliance with the Honorable Guwahati High Court Order of 28/116. How can they do it, my lords? In the Supreme Court, they have said that we are only going on merit. And then now on the basis of the final interstate seniority list of urban program officers, which I have challenged, my lords, here, the provisional interstate seniority list of executive engineer is prepared and is circulated for filing. And at page 235, my lords, again, serial number 2, I am in serial number 2. And R4, my lords, is in serial number 1.
Till the time is not decided.
Yes. So, my lords, for the moment, my lords, I am praying, my lords, my prayer at page 35.
Interview period starts at 34.
Where I have challenged, my lords, my main prayer is challenging, my lords, the seniority list of 18 February 2026 and the legality and validity of the rules of 2025. For the moment, my lords, if your lordships come to page 34, I am seeking, my lords, paying for prayer.
But what the DPC?
Or your lordships may grant me prayer 3, my lords, let them maintain status quo, my lords. They should not go ahead with the DPC. State has much to explain, my lords.
And we were protected by status quo order and Supreme Court.
And from 2016 till 2025, my lords, status quo order was continuing.
Yes, Mr.
Yes,
Chaudhary, you have completed?
Yes, that's all.
Yes.
Lordship, in this case, there are two parts, Lordship. One is two parts, Lordship. One is seniority, Lordship, and other one is the amendment of the recruitment rule, Lordship. So, per seniority is concerned, Lordship. If Lordship come to page 69, Lordship. This particular judgment by division bench of this Honorable Court, Lordship, it starts from page 58, Lordship.
No, we are not concerned with Indian Bench judgment. We are concerned with what you have represented before the Supreme Court.
I am coming to that.
Before that, we go there.
Okay.
Because why you have represented.
Then Lordship.
Now we have you are coming back to it.
Then Lordship, I'm taking Lordship to the recruitment rule of 2014 itself, Lordship.
When has been challenged before the Supreme Court. Right?
Correct.
And there was status quo order passed.
Correct.
And you have represented before the Supreme Court,
Okay.
filing an RA, saying certain other things. So now we have to explain whether those things are correct or not.
Lordship, that my say, Lordship. It's out of the recruitment rule itself, Lordship. My say is not going to change this recruitment rule of 2014, Lordship. 14, what it says, Lordship? Merit.
Then what did you do later on?
Lordship, later on, what happened, Lordship? My statement is not going to alter this.
On the basis of your 2014 rule that you will be complying with the 2014 rule.
Lordship.
Your petition was
On question, Lordship. Question is that, Lordship, my statement in consonance with the Lordship recruitment rule of 2014, Lordship, whether my date say can alter the Lordship the recruitment rule itself or not, that cannot, Lordship. Second is that, Lordship, whether my say will restrain the state government to for all time to come not to power to amend this particular recruitment rule or not, Lordship. It can be amended, Lordship. The recruitment rule has to be seen whether it comes under is permissible permitted under the constitutional scheme of or not, Lordship. That has to be seen, Lordship. What I said is
What was your representation before the Supreme Court regarding this particular case?
particular
A person was involved there.
Correct,
His
Lord.
rights were involved there.
lawsuit.
And you have represented that whatever the promotion or seniority list will prepare as per the 2014 rules.
That is
Now,
there.
that person is, whether you are depriving the person or not,
Lawsuit.
the Supreme Court, Honorable Supreme Court has passed an order on the basis of your representation.
Correct.
Saying that this seniority list and promotion, as far as these candidates are concerned, the petitions were before the Supreme Court will be done as per the rule 2014.
14.
Now coming back, then you are trying to now promote them and prepare the seniority list on the basis of certain other rules. How do you do that?
Lawsuit. That is their lawsuit. I am good. That is their lawsuit. Now, so for the interim is concerned, lawsuit. Until unless lawsuit, the recruitment rule of 2025 itself is not state lawsuit. Then lawsuit, the subject which has come out of lawsuit, that very rule lawsuit, that cannot be state lawsuit.
Your lordship,
Rules
state, my
lawsuit.
lords, for the petitioners.
If somebody's fundamental right is violated by amendment of a rule, we'll stay. What stops us?
Lawsuit, there's no interim prayer. So for
I mean, that can be molded.
Molded.
lawsuit. Lawsuit may lawsuit that aspect lawsuit. The power to amendment lawsuit. Just another thing lawsuit. And my commitment, that may be different thing lawsuit. Lawsuit may own my commitment, but power to amendment is lawsuit is something different.
Power to amendment is always
Always there.
you always have the state will always have the power to amend. The only thing is that with the representation when it was a little bit different. So I mean, as far as these candidates are concerned,
Lawsuit.
it could not apply this.
I'm
But,
grateful.
but subsequently, if you want to do it, you can do it. It's up to you. It's your wisdom, your policy.
Lawsuit.
Nobody is going to stop that. But as far as these candidates are concerned,
Look.
hesitating their right, and Supreme Court has said something, observed something.
Correct.
On the basis of your representation, that they will be whatever seniority or promotion will be done as per Rule 2014. The basis of that, the petition was disposed of. Now coming back, you have amended that rule and you are applying that rule to this candidate. So then you can do that. The state can do that.
Lawsuit may lawsuit.
Your citizens, your own people, your own people.
Correct lawsuit. Therefore, lawsuit, just I distinguish the two things lawsuit. One is my commitment lawsuit. Other one is power to amendment lawsuit.
Power to amendment, nobody is questioning the power to amendment, but
Now lawsuit may say lawsuit this.
amending those things by applying it to the candidates who are before the Supreme Court executing their right. And Supreme Court has disposed of the matter on the basis of certain representation by you. The
Lord.
state is a responsible citizen, and how can they represent something before the Supreme Court and their own person on?
Then in that case, lawsuit may say to lawsuit may say if promotion, if any lawsuit, that may be in terms of to the important lawsuit. In present case lawsuit. Only that otherwise lawsuit, because as I submitted lawsuit, so for lawsuit, the constitutionality of the amendment lawsuit, that is something different law. Let's look at. Therefore, it can't. Therefore, when prima facie lawsuit, that amendment power itself is amendment itself is not illegal lawsuit on prima facie lawsuit.
Yes.
Then lawsuit that has not been it must not be touched by the Honorable Court lawsuit. That very low lawsuit. But lawsuit may say lawsuit looking to my commitment before the Honorable Supreme Court may say that since you have committed, so if promotion, if any, then to the 14th shall be applied. To that extent, it can be.
In respect of the petitioner and
Petitioner.
the respondent.
Otherwise, what I've submitted lawsuit, until unless lawsuit rule of amendment rule of 2025 is disturbed lawsuit. This seniority lawsuit, this cannot be a lawsuit, state lawsuit. Yes. This is the complicated lawsuit situation lawsuit. Because amendment itself is not illegal lawsuit.
Well, this complication has arisen because of the state stand, my lords.
Let's forget about the petitioner and private respondent lawsuit.
No, we can't.
Keeping them aside, whether the state government has got power to amendment or not. That
Yes.
is their lawsuit. But when they are when they are in lawsuit, then lawsuit these complications comes up. Because of I have made some commitment before the Honorable Supreme Court.
My lords, the state's stand is very disappointing, my lords. Very disappointing.
Okay. Mr. A. Chaudhary, Lands General Council, through virtual mode. Assisted by
Mr. J. Karbak.
okay, Land Council for the petitioner.
And my lords, Mr. Karma Dorji, he's assisting me from
Karma
Delhi.
Doji, assisted.
Yes. And my
Okay,
friend there.
assisted Karma Doji, huh? And Mr. J. Karbak,
Grateful.
Land Council for petitioner. Huh? Also had Mr. S. Tapin, Land Senior Council, Government Advocate for the state respondent. You are for? Which? The petitioner has challenged the petitioner by filing this petition under Article 226 of the Constitution of India has challenged the final inter se seniority list of urban program officer dated 18/2/2026 semicolon the provisional seniority list of executive engineers dated 12/3/2026 and the superintending engineer within bracket common bracket clause recruitment within bracket amendment rules 2025 comma to the extent they alter the criteria for promotion staff para issue notice. No, just a minute. It's a petition only. Full issue notice?
No.
Okay. Returnable by
4 weeks.
4 weeks.
Close.
Okay.
The private respondent also is.
Okay. Since Mr. Tapin Lanesh Senior Government Advocate appeared and accepted notice on behalf of the state respondent number 1, 2, and 3. No formal notice need be issued. However, the petitioner shall furnish extra requisite copy to Mr. Tapin, Lana Senior Counsel, Government Advocate, staff. The petitioner shall take steps for notice upon the respondent number 4 by a speed post as well as by usual process within a week from today. Staff. Para. Upon hearing the parties and having regards to the interim prayer made, it is provided that the status quo
Wednesday, new POs.
it is directed that the respondent 1 to 3 shall maintain a status quo over
Wednesday, December. 12 March 22.
shall be maintained with regards to the promotion and the
Yes, Lordship, small prayer. Lordship, at best, Lordship, what petitioner get? That's my commitment before the Honorable Supreme Court. Lordship may provide that benefits to the petitioner and private respondent as per rule to the important.
as regards the seniority.
Promotion, if any, Lordship, then that may be made as per to the important. That's my commitment before the Honorable Supreme Court, and at best, what they can get, that the petitioner can get.
No, the matter has to be heard in depth.
Because, Lordship, when staying the promotion, Lordship, the public interest suffers.
Well, if my friend
We
is
understand.
agreeable, then might as well allow my writ then. He's saying he will follow the 2014 recruitment rules. I have no problem. Let him go on merit.
Correct.
All these have to be set aside. Allow the writ then.
Then the final order has to be passed.
Yes.
Interim. This is the interim, Lordship.
No, interim, you see,
Interim.
their only prayer is, Mr. C, their only prayer is that 2014, we have violated. That is the thing. Now, if we allow 2014 to be, to be followed by you, that means we'll have to allow this whole thing.
Not like that. What I'm submitting is Lordship. Promotion, if any, that may be done as per the 2014 Lordship. But that will be subject to outcome of the present petition.
Okay. Is that agreeable? I think that is.
Here, Lordship, we may win and they may win. We don't know.
Mr. Chaudhary, I think proposition should be acceptable to you.
Yes, it's agreeable, my lords. Then this seniority list will have to go, my lords. This seniority list will have to be stayed because there is no
Promotion,
question of
if any,
seniority.
to the post of the SC. As per the
2014 rules.
2014
But that will be subject to outcome of the present petition.
However, the same shall be subject to the outcome of this present petition.
And my lords, in the meanwhile, your lordships will have to stay the seniority list of 18 February 2026 because that should not be considered by them. If they are going on merit, they can go on merits, my lords. Because this
But
now
that
fixes
part-
the interstate seniority.
Seniority part has been already decided, Lord.
You cannot. That's on challenge. Their case in the Supreme Court was we'll go only on merit. Seniority is immaterial. List has become,
So 2014 is on senior on merit only.
yes, only on merit. Then your lordships will have to stay the final seniority list.
No,
And the provisional
seniority list
list.
has to be stayed.
Yes, and the provisional seniority list of 12.
As per
No, how can this seniority list stay? You tell me.
Lordship, basically,
You have
Lordship,
made this seniority.
when the bidder get
Listen to me. You have made this seniority list on the basis of what? On the basis of merit or on the date of absorption?
That part has to be seen.
What seen?
Yeah.
You see, it is
Student.
very clear
Yes.
from the document itself. You
And
have
it's
not done
based
it
on the
merit.
25 rules.
And then if
Equal
we do
to-
not stay that, if we do not stay that selection list, interstate seniority list, then how you'll give effect to?
Lordship, that part
2014
has been already.
The 2014
The-
rule is your representation before the Supreme Court also, that it will be done on the basis of merit. Now the seniority list that you have prepared, whether you have prepared on the basis of merit or on the basis of date of absorption, you have made on the basis of date of absorption. That
Date.
cannot have effect. It
Lordship,
has
that,
to be stayed.
that part.
So you'll have to prepare a different, if you want to give promotion, you'll have to prepare a separate list on the basis of merit as per
Yes.
2014 rules. You give an effect to that. We don't have any issues to talk.
That part has been already examined by this honorable court.
And the
No, no,
final,
and
and the
Decision has
final,
been rendered, Lordship.
That has
final
got
seniority
Supreme Court.
list of
Lordship,
the urban
very close.
program officer dated
18 February 26
and
and
18 to
26.
26
Lordship.
And the provisional
list dated
12 March
12
2020.
to 12/3/2026. And yeah, and superintending engineer common recruitment amendment rules 2025 shall not be given effective till the next returnable date.
I'm very grateful.
List is
Very
not
good.
after 4.
Very grateful, my lords. I'm grateful for a patient hearing.
Now, these two directions, it contradict to each other. Lord.
How?
One is the seniority. If seniority list is not there, Lordship, because Lordship, as per 2014 Lordship, only merit has to be counted, Lordship. Then
So if merit has to be
Who-
counted, no, listen.
who comes under the zone of
Listen our mind, then you can say.
Lord?
See, if 2014, I mean, whatever the seniority list we have prepared, if that has to be given effective, is it not contrary to the 2014 rules and the
Yes.
representation that we have made before the
That will
Supreme
become
Court?
contradictory.
I'm very grateful.
Yes.
Item number 5,
Well, the challenge in this read appeal has
Let
become,
him start, he is the.
well,
he is the- he is the appellant.
like I have taken consent from my friend. Just,
Okay.
the basic list before the division bench against the judgment rendered by the honorable single judge has become fait accompli because the compensation has been paid already. However, the instruction that I got is that the compensation has been paid and I have to take proper instruction on this, my lord.
You have instructions.
No,
that-
written. So at the convenient date of my friend Nair, it can be 28th May, fine.
To be taken up, it's subject to lordship's convenience. It could be taken up on 20. Subject.
Okay.
Yes.
Mr. Titi Tara, Learned Senior Counsel, assisted by Mr. Bam, Learned Counsel for the respondent number
7. 7, my lord.
7. Submitted. He requires to obtain certain instruction, written instruction from his client regarding the receipt of
Payment.
the payment. Okay. And therefore, praise for listing this matter.
It's not inconvenient, but on 20.
Fine.
Lordship 21.
Okay. 20 May. That
20
means after 2 weeks.
After 2.
After 2 weeks. 2 weeks, Mr. Nair, P.D. Nair, Learned Senior Counsel, assisted by Mr. C. Modi. Learned Counsel for the petitioner has no objection. Prayer allowed. As requested by both the Learned Counsel for the party, list this matter on 20 May.
Lordship 20 is Wednesday.
Wednesday, no, Tuesday or either Tuesday or
21.
Thursday.
21.
21, what is your convenient date?
It will be on 16th.
Yeah,
16.
16, I am not there. 50, we have cases in Basta.
16 or
I think in this matter, no hearing is required anymore, only the instructions, is it so?
Instruction. But if required be, there might be some argument on this. So
You are saying that you have already been paid, only thing is that you need some communication.
Okay, well,
Manoj, may I
16,
just request
16 June.
16 I am, I will
Okay.
be out of
16,
station.
16, 18, any day.
18 is fine.
18, 18 June. Okay.
Grateful.
Item number 6.
Okay. Okay.
There, Manoj. So here, this writ appeal was filed in Guwahati, Manoj, in the principal seat, and this has been transferred, Manoj. I have not been served with the copy, Manoj. I have not been served with the copy of appeal, Manoj.
You serve copy? So you have received affidavit in opposition?
Yes.
You want to file a reply? Okay. Okay. Mr. P.D. Nair, Line Senior Counsel, assisted by Mr. Saxena, Line Counsel for the petitioner who submitted, who had just received the affidavit in opposition filed by the respondent. And he needs some time to go through the same. Okay. Mr. B. Picha, Line Counsel, appearing on behalf of respondent.
Standing counsel, Manoj, rural development.
Okay, Planning Council Rural Development. Submits that he has not yet been furnished with a copy of the writ petition, writ appeal. So the counsel for the petitioner shall furnish a copy of the memo of appeal to Mr. Picha within 3 days from today. Okay. You for 5 minutes. Okay, Mr. R. Sakya, Land Senior Counsel, assisted by Mr. Ibam, is also present on behalf of respondent number 5. So when do we fix? On the same day, on the request of the parties, let this matter be listed on 18 June. Okay.
Right.
Item number 7 to 10.
Items 7 to 10 are writ appeals filed by the state.
Yes.
Writ appeal are filed against this order, whereby stress award had directed to be calculated. They are afraid the matters may be admitted for hearing, but before that, why the main contention? I have just prepared a small list of debts. It's the compensation matter. It pertains to the Greenfield Airport, Kolongi Airport. Before I take you to the document. Yes, this. Initially, public notice, this for that is Kolongi Airport. Then for Kolongi Airport. Public notice was in the year 2012. Thereafter, preliminary notification under the old then acquisition act 1990. It was in 2013. Then second public notice for 22/8/2014. In the meantime, the right to fair compensation act came, and this was not completed. But however, under the new act then a preliminary notification was issued that the compensation will be under the new act. Paid under the new. So that was on 11/1/2019. Then the notification under section 19(1) on 18/1/2019. Matter expedited on this 2019. Then notification also invoking the urgency clause under section 4. On same date on 18/1/2019. Then public notice was given and newspaper publication was there. Made. On 3/2/2019 to receive the award under section 37 on 3 dates 3/2/2019, 4/2/2019, 5/2/2019, and the compensation were received on these dates. Some a bit later also, but compensations were received without, I'll quote here, without any protest. They accepted the compensation without any protest. Then they started filing representation. First representation 22/8/2019, 30/9/2019, 19/12/2019. Here, their contention was that the award was never published, so they didn't know the award, the components of the award. But RTI reply was given on dated 27/11/2019. RTI reply mentioning the amount was given on 27/11/2019 when they filed RTI. Now, after this, RTI reply of 27/11/2019. After this, the first writ petition. Will see the writ petition 193. That is item. This will be item 10. Which actually item 10. Will kindly take up item. This is the first writ petition file. With appeal 50 of 50. I'll rely on this writ appeal. 50 will suffice.
Yes, item number 10.
The list of dates my lord has first writ appeal, my lord. I'll just confine to the list of dates for now, my lord. My lord, we have seen RTI reply furnishing the details of award was given on 27/11/2019. Then the first writ petition 193 was filed in the year 2022. After more than 3 years.
But that is not mentioned here. That is not mentioned here.
In serial number 10.
Serial number 10. Okay. Yes, yes.
Writ petition number 193
Okay.
was filed on 30/5/2022 after more than 3 years. Then the second writ petition was filed 294 was filed and subsequent 174 of 2024 and 455 of 2020.
So those are filed after 5 years. Yes.
After 5 years. Now, in the writ petition, the petitioners, they sought for enhancement of the compensation, saying that award was never published and we were not able to go on for reference to claim enhancement of compensation.
But they don't have any issues about whether under the old Acquisition Act or the new Acquisition Act. That issue is not there.
That is not the issue. Only think that since there are instances of other acquisitions in the nearby locality, they will pay higher compensation. So we should also have been paid higher. That is the only context. They have never gone on reference before under section 64 before the equity, which they should have gone. Now, the writ petition itself was not maintained because for going to the reference also, there are certain limitations. To overcome that limitation, they have filed their writ petition. They were barred by limitation for even preferring a reference before the appropriate possibility. But they have preferred this writ petition to overcome that. Now, that is the first legal issue involved. Whether the writ petition could have been entertained when it was barred by limitation for preferring a reference before under section 64 before the although they say that award was never published, but RTI documents they have, we say that it was published in the newspaper. Subsequently, also we say that we have provided the information under RTI also. Even counting from the date
Of RTA reply,
then also
the limitation is gone.
limitation is gone. The outer limit would have been 6 months from the date when they received the information regarding the award under the RTI. That is my first contention. The second contention is that they have themselves undertaken, they have themselves given affidavits that they are happy with the compensation amount, the award, and we are accepting it without any protest. They have themselves given those agreement undertaking, but subsequently they have filed. All of these things were overlooked by the learned single judge. So for today, since my learned friends have agreed, if this can be admitted for hearing.
Any objections?
Not for admission for hearing, no objection as such, but the contentions of my learned friend are incorrect, my lord. My lord, before the learned single judge, they have not been able to show the award. The award publication in the newspaper, my lord, is it possible? It is possible, no doubt, but is it probable? They will publish the award showing how much compensation is to be paid to whom. What they have sought to rely upon an award is sort of a notice. It is not the award. In fact, under the RTI, they have replied that the award has not been published, has not been made. If it is their contention that there is an award and we should approach the reference authority, where is the award? We can approach the authority only against the award under section 64.
But you have received the money.
My lord, there's an urgency clause invoked. When urgency clause is invoked, 80% of the money has to be paid to us under the law, under section 40.
Correct.
If they pay this advance compensation to us, the 80% of it, my lord, we are happy with that. But where is the award? Some sort of an agreement obtained under duress. Can they override the law?
So we can hear this later.
Yes.
And my lord, the
we can
list of
admit
dates, I have not got the copy.
I think there is now. I mean, there is no interim is concerned, so we can hear it.
Okay.
Here I am appearing on behalf of respondent number 660, madam. Email of India, madam. 60.
Yes.
I can. In first item, madam. And rest, madam, in some substance for the Union of India, madam. Madam, the Union of India, madam, the direction given in direction has been given to the Union of India to make the arrangement of necessary funds, which is also not the in continuance with the notification on the section amount released by the Union of India.
Where is the impugn order? Impugn order?
In item number
50, item number, there, item number 10, annexer,
one, page 49 onward.
page 49 onwards. Okay.
Operative portion is malad para 13 malad. Last para. Operative portion will start from 795. Malad page 95. Malad how Union of India is agreed by. Malad may I take your lordships to the same impugn order para 13 malad. Order dated 19 September 2025 malad.
Anyways, that will be considered.
Malad,
Can be fixed for hearing.
Malad,
that's it.
what I Malad want to make submission is Malad, this is the Malad sanction order Malad.
No, that will be considered. I mean, we are admitting it, so it will be heard.
This may be taken on record Malad.
You can submit it on the next date when the hearing will be taken.
That's because Malad, this is one of the vital documents.
Bring it on record by way of filing affidavit,
Malad, in fact,
so that it will be, otherwise it misplaces.
just the Malad, take on record Malad.
And you are appearing on behalf of?
Airports Authority.
Okay.
Malad, in that case, Malad, may I pray that Malad, I may be allowed to file
item number 7.
sort of affidavit bringing these documents
Yes,
of record.
okay. Heard, Mr. and Ratan, Planet Additional AG for the appellant. Also had Mr. P.D. Nair, Planet Senior Counsel, assisted by Mr.
Mr. S. Rana.
S. Rama, Planet Counsel, appearing on behalf of respondent number.
Well, not many respondents, some of the private respondents.
Only private.
Private
Okay,
respondents.
private respondent. Then,
Malad, I am for the
who is in,
I am for the Union of India, Malad.
Deputy District Land Revenue? Okay, Mr. Dubey for the Airport Authority is respondent number?
62 and 63. AI is 62, 63 is the
63.
regional executive
Airport
director.
Authority, 62 and 63.
And is
And
yes.
Mr. Kato for respondent number 60. His name should come first, huh? Kato for respondent number 60 in
Yes, Malad, in some
first step, and then for Union of
India. Malad.
DSGI, yeah, for Union of India. Okay.
Yes,
The present writ appeal has been preferred by the appellant against the impugn judgment and order dated. Judgment and order 17/9/2025 passed by the Lanish single judge in WPC number. This is 50 is WPC? Is against 193 AP 2022. Oh. It's a common judgment, but then separately it appears separate. Okay. Then issue notice, huh? Since all of them accepted notice on behalf of the respective respondents, the formal notice is waived. Appear and accepted notice, the formal notice is waived. Stop. However, the petitioner, the appellant shall furnish a copy of the memo of appeal to the who did not receive. Oh, sorry. Okay, okay, admitted. Okay. Admit. Okay.
Notice already. It's admitted.
Admit, yes. Okay, then who say that copy not received? List of that. Okay, okay. Then when do we fix? You say. Okay, Mr. M. Kato, Lanet DSG, appearing on behalf of so and so, huh? submits that he may be allowed to bring on record certain documents. What is this document?
Documents regarding my section of the
Regarding-
amount for the construction of the greenfield airport at Colombo. The union.
You want to file in the form of affidavit? Okay, bring on record by, okay, by filing affidavit, the prayer is allowed. Okay, then list it on,
Just for hearing on.
list matter for hearing on 18 June. 18 June. Okay. Supplementary hearing. So what we are trying to do is in the hearing there, so it will be hearing for the DB only. So in the DB there, no, probably if they will try to instruct that no single bench also will be listed. So then in that case, no, not required, I think, for listing the.
So you'll get sufficient time, that's what my.
You'll get sufficient time. Okay. Okay.
Because there is because there is a contempt filed by one of them.
Okay.
Not by the, one of the petitioners has
Okay.
filed a contempt. I think that.
Then- Okay.
I don't think, but there is a contempt. Already item number, 9, in petition number 455, there is a contempt. That's why.
Okay. Okay, having regards to the contention matter, it is provided that till the returnable date, the operation of the judgment dated so and so shall remain state till the returnable date. Okay.
Item number 12.
Yes. Yes.
As for the last problem, what's told from the correspondence whether the FHRC is functioning or not. Not for the last problem.
Okay.
My lord. Well, before I submit the, my lord, status report, in nutshell, my lord, this PL was filed because, my lord, Human Rights Commission was not functioning in Arunachal Pradesh, my lord. Now the agent that, my lord, is functioning, my lord. Retired Justice Indra Shah, my lord, she was the chairman. Then one, my lord, non-judicial member, my lord. It's required, my lord, 3, my lord, 1 chairman, 1 judicial member, and 1 non-judicial member. My lord, what happened, my lord, during that time, my lord, 1 member, my lord, he withdrew, my lord. That judicial, my lord. Then, my lord, it started functioning with the chairman and 1 judicial or non-judicial member, my lord. Now, the present status is like this, my lord. There is only 1 non-judicial member. Now, advertisement has been done for chairman and for judicial member, my lord. Now, my lord, I am told that Honorable Chief Minister already approved that, my lord, proposal, my lord. Very shortly, that will be notified, my lord. Now, my lord, so for status and function of, my lord, human right, my lord, since, my lord, 2024, my lord, is functioning, my lord, actively. This is the status report. If the lordship wants to peruse, my lord, your lordship can peruse, my lord. Otherwise, the main purpose of the PL was, my lord, that it should start functioning, my lord. So that is already, my lord, achieved, my lord. Now, my lord, I don't know for any other, my lord, adjudication left out in this PL or not, my lord. They wanted that it should be start functioning and it's already started functioning, my lord.
Can I just bring on record the
My lord,
advertisement issued by the state,
My lord,
advertisement for inviting the members or the chairman?
my lord, yes, my lord. That we can do it, my lord.
Okay.
Now, I'm told that, my lord, that appointment for chairman and for judicial member has been approved. My
That probably would be required.
It's
So
up to him, my lord. If he's
satisfy the
satisfied, then.
So bring on record then in that case.
And my lord, so far, my lord, status report, my lord. I've been given this instruction, my lord. All total, my lord, there are 41 complaint cases are there, my lord. Out of 41, 30 has been resolved, my lord. Now pending is 23, my lord. So total, it was 56, my lord. So that way, my lord.
What about the staffs and all?
Yes, my lord, staffs
Staff
are there.
infrastructure.
It's already there, buildings are there, it's already allocated to them, my lord.
Okay.
And there are sufficient staffs are there. Now, what is the main problem is here, my lord? Under this act, my lord, they cannot have a regular staff, my lord. All has to be on deputation, my lord. Now, my lord, we have already asked for all the department. There are few, my lord, people there who wanted to opt it, my lord, to go on deputation, my lord. This is not a regular, my lord. So they have to be on deputation, my lord. We have already advertised, my lord. Now, my lord.
That for the staff also?
Yes, for staff.
That means at the moment there is no staff.
There is a staff.
There is, okay.
There is staff, my lord. Total
18 staff.
18 staffs are there, my lord.
Okay, at the moment.
At the moment, one was terminated because of other reasons.
Okay.
That is different method. My lord, secretaries are there, then police, my lord, officers are there, then my lord, field staff officers are there. All total, my lord, 17 are there, my lord.
Okay, so that means only one member, only one non-judicial member.
Sorry,
Only
cut
one
you.
non-judicial member.
Can the human right, this organ can function with only with one of this Human Rights Commission of the state? Can it function only with the one member?
At present, my lord, earlier, my lord, there is a period limitation, your lordship knows, my lord.
Okay.
3 years, if I
It's
correctly
3 years,
remember.
for
Yes,
3
my
years.
lord. Now, my lord, the chairman retired, my lord. So one chairman retired, my lord, we have to issue advertisement, my lord. So that process is completed. I'm told that the Honorable Chief Minister approved, my lord, the for appointment because Chief Minister approval is required, my lord. Now, my lord, chairman and judicial member, my lord. I'm told that their names have been approved, my lord. Very shortly, they'll be notified, my lord. So that way, my lord, we'll be having complete members, my lord. One chairman, one judicial officer, one.
What is that
judicial-
status report? Can I just pass?
My lord, this is the complaint case. Then
Okay.
that they have dealt with agent that, my lord.
Okay. The work, the work they have done.
Yes, work they have done. These are the, my lord, annual report, my lord. I have. Your lordship can peruse. Give it over. It's up to you.
So this is, oh, they have published. Right. Okay.
In fact, the PM was filed for functioning of the State Commission. But the first functioning member was appointed on 15/06/2023. And then one member, he started functioning as per my reliable sources on 31st October 2023. Only he, on that particular day, he started taking matters, especially the import cases. Until that matter is being handled, around 58 or 56 matter has been.
Okay. Let him bring on record the documents. Okay. Because now since they have advertised and the staffs also, I think the present staff, all those details of the staffs and the present, of course, the notification,
My lord,
the advertisement issued.
in our additional affidavit, my lord, we have given detail, my lord, how many staffs are there, what is the sanction.
In the additional affidavit.
Yes, my lord. We have already given, my lord. Now, what they actually wanted, my lord,
Present
the
advertisement.
appointment of chairman and
Okay.
one judicial officer.
Okay.
As I've informed you, have lordship, that it will be notified very shortly.
Okay.
Well, I'm for the respondent number 3.
Malat, we basically
Mr.
have
No.
nothing to do with the Malat. This all Malat appears.
No.
However, Malat, may I Malat suggest one Malat propose one suggestion?
Yes.
That this PL may be closed as because it is functioning well. Malat, the management and the Malat, the recruiting of the Malat staff.
Without appointment of the chairperson, how can it?
Malat, that process has already been
That
initiated.
process is
as-
initiated.
Yes, Malat.
Advertised.
Once the application is filed, Malat, accordingly that will be filled up, Malat.
Sure.
Let them appoint, then it will be closed.
Okay. Mr. S. Mo, Land Council for the petitioner. Start. Mr. Harish Nadu, Land Additional AG.
I am for
Let's
respondent number 1 and 2.
Respondent number 1 and
One and
2
Malat, I'm for the respondent number 3, Malat.
for further. How much time will require to bring on?
Can this be listed after 3 weeks, my lord? Hopefully, my lord, they'll notify, my lord. Hopefully, my
time
lord.
to bring on record the latest development, including the advertisement issued inviting application for the chairman and the judicial members. Accordingly, he prayed for 3 weeks' time. The prayer is allowed. Mr. Nkato, Land Council for the respondent number,
3, Malat.
and then the DSTI, Land Council for the respondent number 3, and you are formed for the respondent number 4. Okay, Mr. Posi, for the respondent number 4 are also present. Okay. On the request made by the Land Additional AG. Okay. So the Land Additional AG is granted 3 weeks' time to bring on record the aforesaid documents by filing additional affidavit. Staff, to enable the Land Additional AG to bring on record the aforesaid documents. Staff, please pray for list this matter after 3 weeks.
After 3 weeks.
Okay.
Develop.
Item number 13.
Sorry, this is this side.
Lordship, our TCR not yet received, Lordship.
Okay. No one for the petitioner.
Today no one is appeared, Lordship.
Okay. So let the trial court record come then.
Yes, Lordship. Lordship, notice also to be served to the opposite party, Lordship, to the company. This is the 302, Lordship.
Okay. Notice was issued, I think that
Yes, Lordship, but it is served or not.
mm,
23/9/2025, whatever was there. In view of the issuance of notice to the complainant automatically stays with you. Okay.
probably
Somebody appeared probably 23/9.
for the appellant also. One Samson was appointed as legal counsel to represent the appellant.
Yes, he is for appellant, Lordship.
Okay.
The complainant has already passed away.
Mhm.
So because of that, I think a notice was waived. 22/9. Yes, 23/9 order, notice has been waived off because of this
Okay.
office note dated 22/9.
Mhm. 23. 22.
Yes, the 22/9. Office note on the basis of the 23/9 order was.
The complaint, however, if it is to the complaint, only the complainant. Okay. Then in that case, no need,
No, sir.
no further notice is required. Okay. Okay. None appears on behalf of the appellant. Miss El Hage Lanet, additional PP for the state is present. Staff. The office note reflect that the trial court record is still awaited. In view of the above, the registry shall issue reminder for trial court record. This is matter after receipt of the trial court
Yes,
record. Okay,
Yes, sir.
that will be. No?
Much obliged.
Item number 14.
Office to the respondent, but as per the record, we showed that late.
Notice was issued. Probably trial court record not yet called for. Record would be necessary.
Yes.
Add Mr. S. Mo, learning counsel for the appellant. Also had Mr. Loy, Lane PP for the state staff. It appears that it is submitted that the trial court record will be necessary for proper adjudication of the case. The appeal, staff. In view of the above, call for the trial court record. The list is matter after 3 weeks. Which court? Who convicted? UPRL. Okay, then 3 weeks. Okay.
Item number 17.
Okay, received. So who is for the appellant?
Lordship. One, appellant, Lordship.
Some legal aid counsel was appointed.
Yes, Lordship. One, Kipa Rimi is there, Lordship.
Keeper Remy.
Kiparimi.
Okay, none appears on behalf of the appellant. Whereas Ms. El Hagelanet, additional PP for the state is present. The Remy also received.
Yes, Lordship. Paper book already received, Lordship.
Okay. The office note dated 25/3/2026 reflect that the Remy is legal aid counsel or MIKS?
Legal aid counsel, Lordship.
Okay, Lana legal aid counsel for the appellant has also received. Sorry, the parties have already received the paper book. Stuff in view of the above, let this matter be listed for hearing after 2 weeks.
After 3 weeks, Lordship.
Why?
Lordship, he is not appearing, Lordship.
Oh, let her appear.
Lordship. Much obliged.
Item number 18.
Yes, name is there. Yes, sir.
Let me get in the remaining terms. I have appeared, and now Public Service Commission has the result, and one of the candidates, but I filed an additional affidavit. In my original affidavit on the page 191, is the seat. I find the only come to page 195. The number 6. My name appears still number 16. So, it is this. After the declaration of the result, some right has been put to me that it's protected for that appointment. This will be my
She was appointed as?
opinion.
Okay, power department.
So you have been selected, you have been appointed. What remains now? Nothing remains.
But
That will be issued. I mean, if you do not get it, then maybe a fresh cause of action will arise. But he has already in the select list.
This whatever will be taken as a stigma for me to further
what was that order? The impugn order?
It's 18 of my.
80. Eight zero.
18.
18.
While this, I think, considered to be hard signature, it's 44.
Hmm.
Paragraph 41.
Hmm.
Very-
Yes.
Having said that, 41.
Hmm.
It is also we get inside that the user is the person with smart locomotor care about. The petitioner is a young citizen of Arunachal Pradesh, and although she is clearly admitted in her reply that she possessed the whole mobile phone during the period of the user, but there being no materials placed by the PPSC to show that the petitioner had used mobile phone during the course of the application in the application hall or even outside. Therefore, this court considers the position of punishment of the government for a period of 1 year to be harsh.
So when the punishment was imposed?
July 2025.
Hmm?
24th July 2025. That is at page number 111.
11?
Page number 111.
Yes.
Last paragraph, start from whereas on careful.
Hmm.
Yes, 111. Whereas on careful consideration, equipment of centers for vigilator for security movement 1 and 2. The admission made by the PWD Caesar covering memo account that report the local officer report made by some recovery of the mobile from you beyond the 2,000 doubt. This fact is also implemented by the made by you before. The place to the big PTSD where you needed getting the bike. The committee also considered the result used by you for the failed to the security moment. It is regard we observe that you Indian statement committed to carry the mobile and that you were not aware that mobile. However, number three, the security one there is the name. They have thoroughly passed you were in private parts not be passed. Further, it's for the element you were taught to the time while you were returning from the work. It is further is the regulation that you are not aware of it, but not the country. Further, there is nothing on the court to indicate. Yes, you have met me and yet court after realizing the fact that you have mistaken the whereas the committee submitted a detailed report to the committee after that all the and the documents on court found you. Eric mobile said that use of the day of concern mind to use the same for the unfair benefit in clear violation of the rules. Another instruction to the court not to take with conduct in the part of the committee. After this was the incident happened, I was from the committee.
So when that examination took place?
December
24.
and was debarred from the committee.
And I also accepted that.
And in that examination, you could not make. Okay, then,
Subsequently,
Thereafter, another,
advertisement came.
no, before that, Public Service Commission, they carried out one other inquiry. And on the basis of that, this department for further one more year. So my contention,
one more year means?
one more year from the date of termination till one more year's time, I was debarred from preparing any examination. And during this 1 year period, this engineering exam also came out. So therefore, had it been from the date of final hearing, because this case was kept
In CAB for some time.
for more than 4 months.
Mhm.
And because of that, my examination,
Okay.
the JEE exam, it was impliedly dividing me from that exam. So I approached the
Close this court, yeah. Then we pass that order.
No, this, with this 1 year debarment is with effect from
The date of judgment.
date of the judgment only. And this was passed on. Okay.
This 4/12/2025. The date of hearing was 2/9/2025. Yes, 18.
Yes.
Judgment 20?
Judgment 4/12/2025.
4/12/2025. Yes, 18.
Hmm.
And if you come to this paragraph
Just
42 of
leave it,
the judgment, it's 44 and 45. And let's read the paragraph 45 of 42 also. Judgment, page 44.
Hmm. Yes.
Second lordship is paragraph 41 and paragraph 42. As held in Prakash Pushpa, that where the situation demands, the quantum of punishment can be molded by the writ court, although it is primarily within the domain of the administrative authority if the writ court is held empowered to decide on the question of quantum of punishment. While for the result this court rejects the consequence of on behalf of the writ petitioner. However, this court considers it appropriate to mold the limit to the extent that under the facts and circumstances of the case, the punishment undergone so far in the opinion of the court is considered is sufficient. The imperial order to the extent it imposes debarment for a period of 1 year is therefore modified to the extent of the period undergone by the petitioner till the date of delivery of this judgment. The imperial order of debarment of 1 year is accordingly modified in terms of the court. The petitioner will now move to appear for different contacted by the Public Service Commission, subject to the law.
But it was delivered within 3 months. Huh?
Was on 2nd September.
It was second of September and 4/12/2025.
Only two. Hmm? No.
No. 2/9/2025. It was the hearing, and it was judgment and that order was passed on
4/12.
4/12. So
Only
it's-
2 days.
so it-
normally 90 days can be kept. Hmm.
Yes. So it's I mean it's 3 months only.
Also, I'm standing in the human case. But now that because of the
Now it's now since you refer to this particular exam, it's probably the department will be already done. Because in the single judge's order also, It was an imperial, one is second, social medical. So nothing remains in the question, and we should not have to come up with that things. I don't think that will be development or the miscalculation for the picture. So you cannot. We cannot take a whole lot of saying that people. But she's not one of the
Yes.
Lordship, the order passed by the single judge, the single judge has not committed any error. Instead, the single judge had only modified the debarment period, Your Lordship. So last occasion also I submitted that this order may not be interfered. But now, by the virtue of interim granted by this honorable court, the appellant was allowed to write an exam. She wrote the exam and she has been qualified. And accordingly, Commission has already declared the result. So
That indicates that she should not be disturbed.
Lordship. So
nothing remains in the.
nothing remains.
Otherwise, nothing
So this
remains
can be closed.
Because knowing that the result will be kept under seal cover, but then the commission itself has decided.
Yes, Your Lordship.
Declared the result.
Yes.
So what we'll do, we'll pass the question.
Yes, we'll pass an order accordingly. See, I mean, the order was for 1 year debarment.
Yes, Your Lordship.
So the learned single judge has said like, or whatever period already gone,
undergone,
that should be taken as a punishment or whatever. So now that has already been over. Now by this court order, she has appeared.
Yes, Your Lordship.
Because it came in between, no? In between that period. Yes. So we allowed her to appear.
Yes, Your Lordship.
She appeared. So now that punishment part is over,
Yes,
nothing remains in this.
Only my submission is that the judgment and order passed by the learned judge has not committed any error in passing the judgment.
No, we are
yes. Without going into the matter, this can be closed, Your Lordship.
It can be closed.
Okay. Mr. T. Portin, Learned Counsel. Yes.
Page 16.
Hmm.
Here the state punishment will be interfered with in the ground of proportionality shall not provide as a stigma or the first matter finding against a therefore we
So this man.
That shall not be barred because of that period is already over. The period is already over. No, she will not be barred. Why? I mean, there is no debarment for her to appear in any of the exams. No, I don't think that will be. She was not working or something like that. She was taking an exam only. It's not her service period or
Yes, Your Lordship.
is a service condition or something like that. It is only the exam. I mean, so many people, I mean, while, I mean, cheating in the exams. So many people are rusticated for 1 year, 2 year by the universities, by the colleges. That doesn't count as a stigma in future employment. There's so many people like there, so many examples. I don't think that will be a stigma because it is not a punishment which has been imposed on her by a DPC or some import committee. It was only while taking an examination, she carried the mobile phone and it was caught. Correct. So that's why, and this is not a service, I mean, condition or whatever that will be counted as stigma. I don't think that will be there will be any problem in that. Because in universities also, there are a lot of incidents happen where this kind of, some people are caught with some cheating materials and all these things. Then they're rusticated for 1 year, maybe 2 years also. But that doesn't give any debarment for him or her to appear in other exams or whatever.
There was no criminal case.
Yes, nothing has been done.
Whether criminal case
Pending.
is pending.
Like FIR has also been filed.
Yes.
Okay. Criminal case is pending. What is the status of the criminal case? CC. Okay. That separate application you can file. Okay. So that it will be difficult.
Regarding Priya
on that.
Lordship, regarding Priya number 2, that was not considered by the learned single judge also. Because in the judgment it says this.
No, that was not considered.
Yes, yes.
Because it becomes difficult. I mean, in fact, there is no need of that. In my opinion, there is no need of that because it's not a service. Which is.
Okay. Also heard Ms. Nanju, then standing counsel for the FPSCC. Hearing concluded. Order reserved, huh? Judgment reserved. Okay.
Obliged.
List is complete.
Yes.
Yes.
Delivery of judgment of item number 1.
Okay. Creative portion, huh? It's a long one, it appears. Revision petition partly allowed with the following direction. Huh? The impugn order dated 1/7/25 is set aside to the limited extent of non-determination of the age of the victim. The special judge is directed to consider the material document already brought on record, including class 10 pass certificate produced, and to pass a region order determining the age of the victim strictly in terms of Section 34(2) of the POCSO Act, read with Section 94 of the JJ Act and Rule 54(18)(4) of the JJ rules before proceeding further with the trial. Yes. Such determination shall be made expeditiously, preferably within a period of 60 days from the date of receipt of this order. The prayer for recall stroke re-examination of the witness is rejected. That is rejected. Huh? Thereafter, the learned trial court shall proceed with the case in accordance with law for the state from the stage at which it presently stands. Okay, disposed.
Acknowledgement.
Delivery of judgment of item number 2.
CRP from 0. Civil revision petition is allowed. The impugn order dated 30/8/25 passed by the customary court of Model Village, Nahalagan, is set aside to the extent that it declines to decide the dispute and recommends the parties to approach the civil court. As a result, the matter is remanded back to the customary court of Model Village, Nahalagan, having jurisdiction with the direction that it shall restore the proceedings to its original file and thereafter issue fresh summon notice parwana to the respondent in accordance with the provision of the Arunachal Pradesh Civil Code Act and the Assam Frontier Administration of Justice Regulation Act as granting reasonable opportunity of hearing. It is further directed that in the event of non-appearance of the respondent despite due service as provided under the Arunachal Pradesh Civil Code Act, the customary court shall be at liberty to proceed ex parte and decide a dispute in accordance with law. Stand disposed. Okay.
Judgment item number 3.
Okay. In view of the above, the petitioner is granted liberty to approach the competent court for modification, alteration of the maintenance amount, placing on record all subsequent development in the matter, including the agreement dated so and so regarding property and liability of EMIs. With the above observation, this petition stands dismissed at the admission stage. Dismissed. Huh? Yes.
Hello, to this petition number 524/2024 for tomorrow listening also.
Tomorrow, list already prepared. Day after tomorrow?
Tomorrow, this for withdrawal.
Withdrawal? Okay.
May, Your Lordship. Your Lordship, item number 11, Your Lordship.
Yes.
I've already taken the consent of the petitioner side, Your Lordship.
Why it has been listed for?
As per office note, Your Lordship, on the last occasion, Your Lordship, the petitioner sought time to file rejoinder.
Rejoined there.
Yes.
Okay, so not yet filed.
Yes, Your Lordship. No,
They have filed.
no, not yet filed, Your Lordship.
Okay.
But with their consent, may it be fixed for admission hearing after 3
Okay.
weeks, Your Lordship.
Mr. Ram, Learned Government Advocate. You want this matter to be fixed for admission,
Yes, Your Lordship.
but you said that they have not yet filed.
No, today morning itself, I have taken the consent, Your Lordship. Yes,
Okay, with the consent of
Yes.
the counsel for the petitioner, list this matter after
3 weeks, Your Lordship.
3 weeks.
Yes,
Order or admission?
admission column.
Okay,
Oblige, Your Lordship.
in the admission column. Okay. Hmm. You're for the petitioner, Mr. Learned Counsel. Sami says, the conducting counsel, Mr. Karyam Davi, Learned Counsel for the petitioner is out of session. Therefore, request for adjournment of the matter for. You are for respondent.
Lordship. For the private respondent number
Okay.
7, Lordship.
Adjournment, seeking adjournment for how much time? 2 weeks. To which Mr.
Yes, sir, Lordship.
Learned Counsel appearing on behalf of the respondent number
7.
7.
Lordship, here,
There's no objection. Prayer allowed.
Lordship, here we have,
After 2 weeks.
here we have filed our power, but since our name has been not reflected.
Where in
Item number 17.
17?
Lordship.
Your name, who are there? Your name.
Yes, we have filed our power in the last one.
Okay, who are there? Who else? You?
Me and my associates,
Okay.
Mr. N. Pada.
Who?
N. Pada Associates.
Okay.
Since the name is not reflecting,
However,
so
his
we
submit
do the
that
correction.
although they have filed Wakalat Nama, their name has not been reflected in the cause list. So the registry shall reflect the name of Mr. N. Pada and
Yes, sir.
Saro in the cause list as the counsel for the respondent number 7.
7. Lordship.
Okay.
Right.
Lordship, I beg to mention item number 10.
Yes.
Lordship, kindly, can it be listed after 2 weeks? Conducting counsel is out of station due to some medical problem.
I appear for item number 10.
Okay. You're for the
Urgency in this matter, in the sense that the validity of the select list of the date list, they have been expired. And they have already filed their affidavits.
They have already filed affidavit.
They have already filed.
What it says?
My lord, our initial selection was based
For
on
two- For 2 years.
for 2 years,
Now they have appointed
only for 1 year.
what they says in the affidavit.
In the affidavit, they said because someone, called Mr. Srinivas, he had resigned after 2 months, that is why they have now done it for 1 year.
But that was no changed. Advertisement was no changed. No, that-
It cannot be changed.
Yes.
after it has been paid.
Yes, yes.
On the basis of that advertisement, I have been selected. Now, after I am selected, in the appointment order, they cannot change the terms.
No,
of
they
the-
cannot. They cannot. As per the advertisement, it is 2 years and an appointment 1 year. How can that be? So who you are appearing on behalf of?
Lordship, I am appearing on behalf of this area. Conducting counsel, he is out of station due to some medical problem. So,
Will it be taken up tomorrow?
Tomorrow?
no, Lordship, kindly, can it be listed after 2 weeks because he went for a medical
It
treatment?
appears that 2 years. When this appointment was done?
My lord, it was done. My lord, 27/8/2020.
8.
8/20.
Still you have some time.
My lord, 6 months. The validity of the waitlisted candidates is 6 months. That is why.
No, appointment not yet done or done.
No, the appointment has not been taken. The terms of the appointment order are contrary to the application. That is why we have challenged.
No. They have not yet issued any appointment order.
They have issued the appointment order,
Not yet joined.
not yet. That is my guess. And they are continuing with the private secretary of the chairman as a, he's a grade 3 officer. Sorry, no, grade 3 employee, a private secretary. He has been asked to discharge from the secretary.
Oh,
And I have, there's a affidavit filed by the respondent number 2, who is a member. Member says appointment. And all my conventions are there in the note sheet, which has been annexed by the respondent number 2. Respondent number 2 says that there was a negotiation, and in the negotiation, I was, my salary was fixed at 2 lakh rupees.
but there is a scale. It carries scale. It carries scale as per advertisement.
But since it's a retired employee and for contractual employee, that negotiation can be done.
Can be done.
In terms of that.
Okay.
So that was done.
Oh.
And the chairman had assured to issue the appointment order very shortly. This is reflected from the note sheets. Going, my lord, behind the backs.
No point. I think keeping it pending, because appointment it is all for 2 years, and then the wait list is for 6 months.
6 months.
When it is going to expire?
My lord, they say in their affidavit that the document has not been released. The respondent number 2 as well as the respondent.
Okay.
They have said in the affidavit, but no doubt.
Oh. When can he come?
Lordship, after 2 weeks.
No, that is it.
Affidavit is there, the stand is there.
Mr. Kaji, are you also appearing here?
I am for respondent number 2.
Who is respondent number 2 is?
The member.
Oh, another member.
Yeah.
Why you have implemented another member?
My lord, they have included the chairman, member, and the private secretary as the respondents.
Okay.
So chairman has filed a different affidavit, and my
You are for chairman.
Yes.
Okay.
and the private secretary in person, but he has filed it by designation.
By designation. In person, why?
My lord, Malafide.
Okay.
Malafide is alleged.
We'll fix it next week or what? You give your convenience there, because today it cannot be. Okay, Mr. Planning Council submits that who is out of state?
Disekya.
Planning Council for the respondent number 1.
1 and 3.
1 and 3 is out of state. Planning out of the station, therefore pray for adjournment of. Who would be conducting the case is out of the station, therefore pray for adjournment of the matter. However, Mr. P.D. Nair, National Senior Counsel, assisted by Mr. Torofon, shown some urgency in the matter. In view of the above, and age prayed for, come and list this matter on 20 May. Okay, Mr. Nilam Tajib for respondent number 2 is also present. Okay. Okay.
Highly.
Your Lordship, I would like to mention item number 7, 8, and 9. I'm appearing on behalf of S. Koyang, counsel for the petitioner. He is currently out of session. May this matter adjourn for after 2 weeks.
You are for the petitioner?
Petitioner.
Why you are taking the place of the respondent? Come to your own place. Okay. Yeah, Mr. And probably item 7.
7, 8, and 9.
Okay. Mr. Indor and M. Dolia, Planning Council submits that the conducting council, Mr. S. Koyang, is out of the station. Therefore, pray for adjournment of the matter for 2 weeks. To which
Your Lordship,
Planning Nominee Advocate has no objection. Prayer allowed. Please this matter after 2 weeks.
Your Lordship, till date, they have not furnished us with the extra copy, Your Lordship.
Okay. In the meantime, the petitioner shall furnish the requisite extra copy to the Planning Council appearing on behalf of the state respondent within 3 days.
Today onwards,
Okay, yeah, during the course of the day. Okay.
Obligation.
Yes.
Item number 4.
Okay. Admitted, not yet. It's for admission only. What is this matter about?
Your Lordship, this is suspensive matter, Your Lordship. Here, affidavit has been filed, Your Lordship.
Affidavit filed.
Yes, Your Lordship.
Okay. Heard Mr. Chitaju, learned counsel for the petitioner. Also had Ms. Pangu, learned government advocate for the state respondent. All the respondents.
Yes, Your Lordship, 1 to 5.
Okay, start on. It is submitted that the pleadings are complete and the matter is ready for hearing. Okay. Since the parties are duly represented and pleadings are complete, let this matter be listed for hearing after 3 weeks. Okay.
Organize, Your Lordship.
Item number 5.
Yes, Mr. Modi.
Last occasion, after getting to the certain extent of this case, the court has smaller conversation too, by right, this can be filed under the PNS. But in my further instruction to the petitioner, if the petitioner is still in dilemma whether this case to proceed or not. Therefore, I am going for.
Now, why should you be in the why have you filed this in a writ petition in the first place? Because your prayer is for the investigation only. It's a CRPC or BNSS. There is a provision straight away.
That was of the best.
173(8) CRPC probably.
Yes,
Eh?
So, my lord, whether to.
Or now you can come under 528 or 482 the CRPC. So better withdraw and come again. It appears. No point here. How the writ court will direct when there is a provision.
Will be next.
Hmm.
Let it meet after 1 week.
Okay.
Because the petitioner itself is.
Okay. Just tell the petitioner how the petitioner would know. They are not law graduate. You have to suggest. And then if you file the wrong application, then they'll blame you rather. It's you to take steps. Suggest or advise the client. They have given the brief fact, everything. It's duty of the advocate to do the needful. Okay. As prayed for by Mr. C. Modi, not being objected to by Mr. Lanet PP.
No, government advocate.
Oh, government advocate.
Yes, sir.
Oh, sorry, double PC, sorry. List this matter next week. Okay? List this matter again. Otherwise, right, relist it on next week. Okay.
Obligation.
Item number 6.
Yes, and Malad.
Yes.
In this matter, I have received the instruction, Malad. I have sent it for law waiting, Malad.
Okay.
I yet to get back that, Malad.
Is it? Okay. It's against the government. It takes time. So now they have received, they will file, we'll give some time.
Same submission is making the
And you are also making the same submission.
Yes.
Okay. Then court will also pass same order on the prayer of El Parme. Mr. El Parme, Lanet Standing Council, Power Department, Sami said he has received an instruction. No. The affidavit is ready.
Yes, after that I have sent it for the awaiting, my lord.
Affidavit, after preparing affidavit, we have sent it for vetting, which is still awaited, and therefore pray for some more time. Judge, Pango, are you also filing?
Yes, sir. I'm for respondent number 1 and 2, your lordship.
Yeah, respondent number 1 and 2 is also filing any affidavit?
No, your lordship.
No,
Go
okay.
by the affidavit filed by-
Okay. Mr. Okay, Dugong. Oh, Dugong, Land Council for the petitioner has no objection, provided a date, a fixed date is given. And provided the respondent file their affidavit by the next date. Miss Pangu is also present on behalf of the state respondent number 1, 2, and 3.
No, 1 and 2, your lordship.
1 and 2 staff is requested by the council for the petitioner. This matter again on 18 of
22, 21.
how,
Let it be, my lord.
how much time it will take, Mr. Norman?
2 weeks, my lord.
2 weeks would be when? After 2 weeks. Okay. Fixed date. Why? What is
25, my lord. 25.
What is this matter about, Mr.?
This is
Executed? Okay, bill not paid.
bill.
Okay.
25, my lord.
25.
25, 26.
Okay.
Obviously.
No, sir, let's see. Item number 12.
Yes.
Pleadings have been exchanged, Your Lordship.
Hmm?
Pleadings have been exchanged, Your Lordship.
P 7 and 8. Probably not yet.
Okay.
None appears on behalf of. Okay. Just a minute. Huh? How many respondents are there?
12, Your Lordship.
12.
Yes.
Okay. The office note dated 4/5/26 reflect that the notice upon the respondent number 3, 7, and 8 are still awaited. In view of the above, this is matter after 2 weeks. Okay. Mr. Riram Lanit, government advocate, is present on behalf of the state respondent. Okay.
Oblige, Your Lordship.
Item number 13.
All the respondent is filed here. Only the respondent number 4 is
Oh, who is respondent number 4? Private?
Yes.
Who appeared for? Whether they appeared earlier?
Michikambo.
Never appeared.
They appeared.
Oh, they. What is this matter about?
Passing of the legal expertise order. Is so passed by the deputy commissioner.
Okay. What is the order passed by Deputy Commissioner?
Issuing
Okay. Miss, Mr. Okay, Mr.
Yes, sir.
Land Council for the petitioner who submitted, except for respondent number four, all the state respondent has filed their respective affidavit. None appears on behalf of the respondent number 4. So his affidavit is necessary otherwise. Okay. Miss we are present, is present on behalf of the respondent number 1, 2, and 3. In view of the above, the respondent number 4 is further granted 2 weeks. Further 2 weeks time is granted to respondent number 4 to enable him or her to file affidavit in opposition, if any. So list is met after 2 weeks. Okay.
Item number 14.
May I please the Lordship, my lord? I'm on VC, my lord. This
Yes,
matter is raised to contempt, my lord. The pleading is complete. So Lordship may fix the matter for hearing, my lord, subject to convenience. My lord, last part of June.
Okay, hard Mr. A.K. Purkastia. Also hard Mr. S. Tapping for.
I'm for respondent number 1 and 2, Lordship.
Okay,
In contempt number 0.
Government advocate appearing on behalf of respondent number 1 and 2 and
3.
Okay, then Mr. Kogi for respondent number 3. Okay, it is submitted that the pleadings are exchanged and pleadings are complete and the matter is ready for hearing. So, as requested, let this matter be listed. When you say? When?
My lord, last part of June.
Last part of June. List this matter during the last part of June. 28. 28 is Thursday.
Yes.
No, 28 is Thursday. Will not
27?
fix on the TV day.
My lord, 27 then.
Okay, 27 is holiday.
25th, my lord.
Okay,
That is
26.
Thursday.
Okay, 25th. Okay, 25th June. For hearing, huh?
My lord, next item is same. Is also contempt matter. Pleading is
same.
15.
Here also, then similar order here, huh? Here also.
I'm not there.
Okay, where you go for? Sole respondent. Okay, only his, huh? Purkastia. And then go for respondent, sole respondent, huh? Same or similar order, same day. Okay, 25th June.
Obliged, your lord.
No correction. Not the SA incapacity of government.
Yes, step in for the respondent number. Yes.
Obliged.
Item number 16.
Lordship, in this matter, I'll be appearing for respondent number 4, that is private respondent. I filed my wakalat number today, Lordship.
Okay.
So some more time may be given, Lordship.
Okay, Mr. Mukbom, Land Council for the petitioner is present. Stop. Mr. Tijamo, Land Council would appear on behalf of the respondent number
4, Lordship.
4.
Your Lordship, I'm for 2 and 3, Lordship.
By filing wakalat number and appear on behalf of respondent number 2 and 3. Okay, and one for respondent number 1 and 2. Only one. Okay, on 1. So you want to file?
We'll file affidavit, Lordship.
Okay.
We'll also file the petitioner to file and petitioner.
Okay.
That case, Lordship, let the petitioner file the additional affidavit.
In that case. Okay, then leave the earlier one. Mr. Mukbom Pertin, Land Council for the petitioner is present. who submits that there has been some subsequent development, and therefore he may be allowed to file additional affidavit to bring on record certain documents, new documents. Okay, the prayer is allowed, Mustafa. Then Mr. Jamo, and then one was present, first recorder for the respondent number 1, and Mr. for the respondent number 2 and 3. Are you filing? Okay, later on. Okay, Mr. Jamo, Mr. Jamo also would appear on behalf of respondent number 4 by filing wakalatnama, Mustafa. In view of the above, and as prayed for by the Land Council for the petitioner, list this matter after 2 weeks. Okay. Thereafter only.
Yes, Lordship. Deeply obliged.
Lordship, matter is over.
Oh. Sure.